This goes in that file. Court does call the case People versus LaPortia Murray. I was. See how that goes. I called it.
Good morning, Your Honor. Sam Bernstein with on behalf of Ms. Murray, who's seated at counsel's table.
Okay. This is the date and time set for the continuation of the preliminary examination. However, my understanding with the medical examiner, there were some date confusion. So we had proposed alternative dates. He is not available. My next preliminary exam date of June 11th.
That's he actually was it, but I believe that Mr. Bernstein had a conflict. Which is,
okay.
And then in response that we were provided the kind of off date time by your staff of a week from today, 28th at 1 p.m. I did speak with Dr. Tashian late yesterday. He can make that work. And we, as we communicated to your staff, we don't expect this in continuation to take any longer than an hour in total.
Still sounds good, Your Honor.
All right. I will adjourn it. This preliminary examination to what's that, the 28th? May 28th, 2024. 1 p.m. And that's before me. That's a continuation. And just so that counsel's aware, as I'm sure you would be, that's a Tuesday. So we'll be waiting at courtroom because of her in custody status to come back to my courtroom. So I'll say 1, but hopefully we can start at that time, maybe not.
You're at the pleasure of the court, however long it takes, Your Honor.
Really?
Have a great day.
I got that in the last case too. No, I'm just kidding. Court calls the cases of the People versus Michael Deshaun Kyle. See, he's in. We know what it is. That's what he's putting.
Yes.
Oh, just one kind of deviation. Okay. Whose case is that one? Come on up. I think we're taking a plea. All right, counsel. Court does call the case of the People versus Kyle.
Ready, Ms. Manager, John Brown, Deputy Chief Public Defender, on behalf of Mr. Michael Kyle.
Deputy Geraldine Bledsoe Ford, attorney for Mr. Kyle.
All right. Pardon?
Our case is 1, 2,
2, 1, 2.
24 years ago.
All right, what are we doing?
I offer the defendant can no contact to count 3, the domestic case number 24-1212. Upon a successful no contest plea to that domestic violence count 1 and count 2 in that file will be dismissed, and case 24-FB1225 that file will be dismissed as well as part of that agreement. There are no further agreements, and that should be it.
That is our understanding, Your Honor. Later at the appropriate time, we'll be asking for furlough for my client as his grandfather passed.
Certainly you can ask, and I will just say this. I've been dealing with a couple of furloughs from your office. I thought we had a criteria laid out, so I hope I have all of the criteria laid out so that I don't have to deny it because I don't have everything that I would need, but we can go through that. I just indicate that.
We just found out, so I'm pretty sure you don't have.
I won't have, okay.
His grandmother did call me though and advised me that the funeral is Saturday, this Saturday, that he had passed and that the funeral is this Saturday.
Okay, but what I'm indicating is that I'm going to need certain information before I would even consider granting it. I have a criteria for the granting of the furlough, so.
Just to make matters worse and more complicated the way that I like to, the defendant also has a rule from Jackson County for a violation of probation there. So even if Your Honor were to grant it, I don't know if that would make him eligible for Jackson County to get him.
Got it.
I don't think furloughs necessarily as that, because the way other counties get possession is that.
Yeah, but we don't do anything like other counties.
Sorry,
we don't do anything like other counties. We do it right here in Washington, so I don't know.
That's all
right.
Relinquishing the claim on our land.
All right. Okay, so that was a correct statement of the agreement, counsel.
Yes.
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Michael Kyle. Sir, it is this court's understanding that you're going to plead guilty or plead no. So no contest? Yes, no contest to the charge of domestic violence.
The reason for that is potential civil liability.
Thank you. That is a misdemeanor. It is punishable by up to 93 days in jail, up to a $500 fine plus court costs. You understand that, sir?
Yes.
All right. You also understand what a no contest plea is. All right. Let me explain 2 things about it just to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B district court.
Yes.
All right. Understanding all of that, you still wish to plead no contest. And to that charge, how do you plead?
No contest.
So you understand that by pleading no contest, you'll not have a trial of any kind.
I do.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yes.
Bless you. You understand you're giving up your right to appeal upright?
Yes.
Are you on probation or parole?
Yes.
Were you on probation or parole at the time of this offense? You understand this could be considered a violation of that? You were on probation?
Yes.
Okay. It could be considered a violation of your probation. You understand that? You understand that if it is considered a violation of your probation, you could be sentenced to the maximum allowable under those other charges.
Yes.
Has anybody promised you anything to get you to plead to this charge other than what's been stated here today on the record?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 24-22181. Any objection to the court having reviewed that report?
No
Your
objection.
Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this charge. Counsel, have I complied with the court?
The defense is satisfied, Your Honor.
Satisfied, Your Honor.
People are satisfied, thank you.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 in case 1212 are dismissed, and the entirety, I guess, the one charge that is contained in the case ending in 1225 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
June 24th at 7 a.m. before Judge Washington.
June 24th, 2024, 10 a.m.
Yes.
10 a.m. before Judge Washington.
Your Honor, one further thing, my client has asked me to address the bond in this matter, understanding he does have a hold, Jackson. He's asking that he be allowed to have his bond reduced. It's currently still, but in this matter.
100,000 cash, or 10%.
So he's asking that now that one case has been dismissed, the other has been reduced down to the DD first, the misdemeanor in this case, that the bond reflect that. He's asking that the bond be set in this case at 10,000, 10% allowed.
Response.
The bond does reflect that. When I office charged this case, we requested 100,000 cash surety on this regulation case. Then we charged the now dismissed witness interference case. My office requested another 250,000 cash surety. The fact that we entered into a plea agreement does not take away from the fact that the police were called. A neighbor had to call 911 to make sure the victim was screaming for affirmation. When the police arrived on scene, they heard what ended up turning out to be the defendant. They heard a male voice yelling and irate and confronting the victim about possibly cheating on him. The victim answered the door. The victim reported to the police that she was asleep and she woke up to the defendant strangling her. The police observed a bruise on her neck that was consistent with what she reported to them. She reported that after she was strangled, the defendant threw her to the ground. The defendant took her phone from her, preventing her from calling 911, and that he stabbed his grandma on the phone, and him and his grandma told her not to call the police. This then dovetails into the very long forfeiture argument that Your Honor heard, I think it was just last week, regarding the defendant's interference with the victim's presence today. Your Honor, the bond being set currently at $10,000 does reflect this is now a misdemeanor domestic violence case. Then, as Your Honor knows, she has a rule for Jackson County. Thank you, Your Honor.
Is there a 10% privilege allowed in the 10,000?
In this case?
Yes. Yeah. Oh, I'm sorry.
Yeah, that's okay. You did a Chinaza argument almost.
So what we're asking for is $1,000, 10% privilege on that.
What, it's 10,000, 10%?
No, 1,000, 10%.
It's 100,000. Right now.
Okay, all right. So I
It's
asked for
100,000, 10%. It is set at 10,000, basically.
All right. So what I asked for was 10,000, 10%.
It is?
That's what I asked for.
It is denied. I mean, I've considered everything. I've looked at it. I've read the police report. The bond is set, although it's set in an interesting way with 100,000, 10%. I might have done it a little bit differently with 10,000 cash surety. I think that bond is appropriate as it's set. So the motion for bond reduction is concerned.
Thank you, Your Honor.
Bond will continue.
So right now it's currently set at 10,000 cash assured,
No, I left it where it was.
which is 100,000. I see these numbers. I
I
got
mean, I know you went to Michigan, so you'll never get it. Let me talk to you. It's 100,000, 10%, which is 10,000.
okay.
And I said, I would deem an appropriate bond in this case to be a 10,000 cash surety, which would in effect be the same thing if I were to do it that way, given the charge.
Thank you, Your Honor. Thank you for letting me go over the facts again, even though I forgot it was no offense. Thank you.
Yes, I recall it. And the furlough, I want to make sure I'm clear on that because where is I mean, there are ways of securing him if that were the case, but there's certain information certainly that I would need in terms of obituary, who it is, notice to the prosecutor of when you want the release, when the services are, I need all of that information to make that consideration. Doesn't mean I would grant it, but I would look at all of that.
My client can put it on the record. I don't have it physically, but he can put that in.
No.
Under oath.
Certainly he could put it on the record, but I need it in writing
All right,
that
so
he's
I will-
requesting the furlough because everything would have to be in writing.
So what we can do, Your Honor, so we can get that office, can get that information. He's going to call us this afternoon, give us that information. We'll send it both to the prosecution and to this court, and then the court can.
Right. And then I can make my decision on that.
And will he be allowed to contact his family so he can get that information?
Here's the problem. He might want to give you information to contact because his phone privileges have been revoked.
The charge has been dropped, dismissed. That's the one that was
Privileges
dismissed.
are revoked in the domestic violence case.
Or they were revoked in both cases.
So given the fact that it's been resolved, well, we
No.
can-
No, because what ends up happening, the basis for the revocation and what added to the charges that got ultimately dismissed was his inability to use that phone properly as well as do other things. So I'm not giving that back to
I have
him.
an idea, Your Honor.
Okay. Yes, Colin, that's
The
it.
grandmother-
Go ahead.
I'm sorry, I'm
No.
sorry, but it is on point. The grandmother called me. She reached out to me. If I can get her name and number from him, then I can give the information.
Absolutely.
Okay.
Yeah,
That-
because.
She's the end game, the goal.
I just want to say I do.
Okay, all right. That's what I thought. I thought there was a family member that contacted one of you.
She contacted us.
So we can get that information and we can see what can be arranged.
All right, we got it.
Okay, I'm not guaranteeing anything, but at least give me the information stuff to look at.
So if you give
Right.
Is that right? Look at it.
Thank you.
I'm going to step next door to Judge Aldo's court.
I'm sorry.
I'm going to step next door to Judge Aldo's court. She's at her court officer in custody. So I'm there to start.
Oh, she didn't have to, we could have just done it. If you had said lock use up. We would've- This is Miss Hughes?
This is what you're bringing out. It's a waiver.
Hold it, real quick, there's a waiver. That's your case?
I got it. Let's see.
Yes.
Yes, got it. Wait, straight away. Sounds great.
Why? You just want to leave? You know, all right.
I really don't
When she
want to
comes,
be arrested.
when she comes back, we're taking her in. No, I'm not telling on you. I would never do that.
No, we're not. There.
There, okay. Court does call the case. So the people versus Jamie, is it Poliski?
Absolutely for the people.
Assistant Public Defender Otello Vitella on behalf of Mr. Poliski, who's appearing to my right. Thank you, Your Honor. Today is the time and date set for preliminary exam. I've gone over the rights of preliminary exam with my client. He has understanding of those rights, and I'm going to have him sign the waiver.
Okay. And sir, is that correct? That you're waiving your right to have a preliminary examination?
Yes, Your Honor.
And you do understand that's a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the right.
We do.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following. Counsel,
I'm sorry.
your turn.
Oh, yes, I'm sorry, Your Honor. Your Honor, we waive a formal reading and stand mute.
Defendant having waived formal reading, standing mute to all 3 counts, court will enter a not guilty plea. Pretrial will be set for
June 3rd at 1:30 before Judge Slay Monday.
June 3rd, 2024, 1:30, Slay Monday.
Thank you, Your Honor.
Thank you. Bond in this matter will continue.
Thank you kindly,
Thank
Your Honor.
you. He didn't ask for you to be his attorney.
Not-
Just thought I pointed out. Just as I pointed out. You're not liked by everybody. Just wanted to make that real clear.
That's the only one we can do because she was on this one and everything. Yes.
So who's on this one?
Line. Yes. He was engaged on this one.
So he's engaged on that one.
Okay, let me go make this call. Court will take a 15-minute break. I'll come back and I'll handle my 2 last ones and we'll do this.
All rise.